The trial of Geoffrey Paschel on the docket again tonight. We saw the trial here on Court TV. He bragged, sort of, not only bragged, but kind of talked about the fact that he was offered a deal for no jail time, but turned it down because he was innocent, went to trial, was convicted, and is now serving 18 years in prison, but wants a new trial. Joy Lim Nakrin has the story of the 90-day fiancé, Geoffrey Paschel.
We, the jury, found the defendant, Geoffrey Ian Paschel, guilty of aggravated kidnapping.
Once a reality TV star, Geoffrey Paschel is now a convicted criminal.
Sir, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Please have a seat.
But now he's asking for a new trial.
I know that Geoffrey feels strongly about the issues that we raised. Mr. Paschel is looking forward to having this addressed at a higher court.
That's his attorney, Gregory Isaacs, who filed this motion for a new trial after Paschel was sentenced to 18 years behind bars for attacking his girlfriend, Kristen Wilson Chapman, at her Knoxville, Tennessee home in 2019. Paschel downplayed the confrontation in his testimony at trial.
The incident occurred at the house based on her jealousy. Ever since then, it's morphed and it's made its own way to different things.
The jury didn't buy it. They found him guilty of aggravated kidnapping, domestic assault, and interfering with an emergency call after his victim gave powerful testimony against him.
The next thing I remember, I was on the floor in front of my staircase that leads to the upstairs, and he had me by the back of my head and was hitting my face into the floor, and I was screaming for him to stop.
Before he made news as a defendant, Paschel was featured on the show 90-Day Fiancé Before the 90 Days, where fans once tuned in to follow the budding romance between Paschel and his Russian girlfriend, Varya Malina.
I don't want to die.
Paschel's popularity plummeted once fans learned of the charges involving Chapman, and he was promptly dropped from the season finale while publicly vowing to fight the allegations.
This is all just a ploy. This is all just an agenda to try to make me lose custody of my child.
At trial, Paschel's attorney says Chapman made a prejudicial statement that came as a surprise, claiming Paschel had abused her before.
We are completely entitled under Tennessee law, like most jurisdictions throughout this country, to pretrial notice of 404B. And then there has to be a hearing to determine if the evidence or the prior bad act is admissible by clear and convincing evidence. So we were denied that procedural and substantive due process pretrial to contest this allegation.
The claim is one of 9 grounds Paschel cited in his motion for a new trial.
We think that they are all viable arguments that are contained in the motion for new trial, which is basically the foundation for Geoffrey's appeal to the Tennessee Court of Appeals.
Meanwhile, his attorney says celebrity status should not cost him justice.
Anytime you have a client that, for lack of a better term, is high profile, which is the term I think that we overuse, but you tend to get lost in the court of public opinion sometimes. The trial, the motion for new trial and appeal will be based on what took place within the confines of that courtroom.
All right, there's 2 parts to this, right? Number one, it's a real issue, this 404B. We'll get to that in a second. But more fundamentally, you're going to the trial judge to get the new trial. Let me bring back in my think tank, and I want to start on that note. Amali Palmer, my guess is most trial judges don't want to do the trial again, right? Because the basis to do it again would be that something wrong happened at the first trial that they were in charge of. So you're basically calling out the judge on a motion for a new trial, aren't you?
No, Vinny, I would like to believe in our system of justice that most judges would like to be fair. And if there was some error, maybe it was the prosecutor's fault, right? Maybe they made some sort of argument that was inappropriate and the judge believed them erroneously. They can blame the prosecutor, for example. But I like to believe, Vinny, that those of us that do a lot of post-conviction litigation, that when we go back in front of that audience, that they are trying to be fair and get it right and own up to a mistake if there happened to be one. I don't think that judges who are sitting there in these very high, serious positions of power are taking it personally when a litigator comes to them and says, look, here's the law, here's how it was misapplied, and we get to do it over. It happens all the time.
Yeah, I get that, but I would think judges are very thoughtful the first time through. That like they're not just willy-nilly making decisions. Hey, let me take a quick survey. How many of you have made a motion for a new trial and the judge said, let's do it? Carmen, tell me the story. How did that happen?
Oh my goodness. Well, it was an ineffective assistance of counsel claim. So I do a lot of motions for new trial, and generally the ones that you actually prevail on are when something fundamental breaks down, as Molly said, like when counsel doesn't do what they're supposed to do. But in this case, these are mostly evidentiary issues. And so this motion for new trial is not about going back and getting this judge to second guess what he decided at that time. It's really more about making a record for the appeal, because especially as regards these prejudicial 404B statements that came in, they're going to have to show that they were harmed by that and really create the record that I don't know that they did in the trial, so that they can have something to actually prevail on when it comes to an appeal. So a motion for new trial is not always about winning. Sometimes it's just about making a good record to win on appeal.
All right, now let's get to the real big picture here, Renee. Again, before the trial, in an interview, he said, and again, I haven't verified it with the prosecutor, but he said he was offered a deal for no time, 0 time, went to trial, 18 years. Now, whose fault is that?
It depends on what was presented to him in discovery. It depends on what the discussions were with he and his attorney. But, you know, when you have a situation where a resolution is offered to you and you have to weigh the odds between no time at all and you know what's going to happen and the possibility of 18 years or 20 years, those are real offers that should be seriously considered. It's not like the offer, you know, like he's facing 10 years and the offer is 9. You know, for that, you're going to go to trial. So in this instance, he was offered a deal with no time. He really should have seriously considered it. But some people say, listen, if I didn't commit the crime, I don't care what the recommendation or what the offer is. I'm not pleading guilty to anything because I didn't do it. But those who take that position also have to be willing to roll the dice and willing to suffer the consequences if it doesn't go in their favor. But 18 years, you know, is very significant. And a client should not be punished. Their punishment, their sentence should not be more punitive because they exercise their right to go to trial.
But
the punishment needs to fit the crime.
But,
it needs to fit the crime.
But shouldn't it be less punitive if they accept responsibility?
Well, certainly if they accept responsibility.
Well, that's what it was. Accept responsibility, you get 0.
However, you should not receive an enormous amount of time because you exercised your right to go to trial if you are still maintaining that you are innocent of this crime.
So what you're advocating is prosecutors not offering a good deal.
Well, you know what?
Because you would have no problem. If it was offered 12 years, you'd say, all right, it's fine. He really, you know, that's fine. But because he got a good offer, you're not happy with him.
But here's the thing, and this is what you got to think about. If the prosecutor offered no time, right, if that's what they thought was appropriate at the time they made that recommendation, and then he opted to go to trial, if he's convicted after trial, why isn't that same recommendation appropriate
Because
now
he's
you're
not
just trying to
accepting
punish him
responsibility
because
for what he
trial.
did.
But you're punishing him because he went to trial, because he exercised his rights. Not because you're giving him the sentence that you think is appropriate.
It's all from your perspective. I was greatly rewarding him for being a man and stepping up and saying, yes, I did it, which I think people, they should get the benefit of accepting responsibility. All of them should just walk in and accept responsibility.